Good morning, everyone. It's great to see so many of you on here. We're really delighted to be speaking with you this morning for the latest of our People Matter webinar updates. You've got two speakers for today. So there's me, Abisola, and I'm joined by my colleague Francesca, and we're going to be delivering an employment update over the next 30 minutes or so. So for those of you who are able to join us at our last webinar in April, we covered principally the employment updates relating to the Employment Rights Bill, clearly a very significant piece of legislation, as we'll come on to in a moment. So we're going to look at what's changed between April and now, what updates have we seen, and what does that mean for you as an organisation. If you weren't able to join us at our last webinar in April, then that is available on our website, so feel free to look at that. But as I say, what we'll be doing today is bringing you up to speed with all of the latest developments on that, and then also a few other government proposals as well. And then crucially, we'll be looking at what impact do those changes and developments have on your organisation, and what can you be doing to prepare for them. So if we kick off by Francesca having a look at where we are now with the Employment Rights Bill.
Hi, good morning all. Yes, so as Abisola said, we've got the Employment Rights Bill, which has been a topic for many and has been a discussion for quite some time now, but rightly so, as it's the biggest development in employment law in almost 30 years. So we have had a long journey, but we're almost there in terms of finalising what the ultimate act will look like and how it's going to impact and the rules and changes in place. So if we have a look at the journey from it becoming the Employment Rights Bill to it becoming Employment Rights Act. So it is in the final stages of Parliament at the moment. So since our last update in April, we've been going back and forwards between the House of Commons and the House of Lords as Parliament tried to agree the provisions. We're at 330 pages for the bill, so around double of what it was last October. But next week, on the 28th of October, the bill goes back to the House of Lords, where it's anticipated that they will back down on a number of amendments that they asked the House of Commons to make in July earlier this year. And if that's the case, the bill will then be in final form, ready for royal assent, and it will then become an act. So we anticipate that will be, in terms of timescales, around November time. That isn't the end completely, because most of the provisions need regulations to flesh out the detail of the act, of the changes in place. So the Act is the framework, if you like, and the regulations are the rules on how to comply with the changes and also the timescales for them coming into place. It's expected that no fewer than 80 regulations are needed to implement the bill. So again, it is quite chunky, and we are waiting on quite a bit of detail. If we have a look at the implementation itself, we've got 4 phases, but what the government have said is that they want to give sufficient time for employers to get to grips with the changes and how to implement them. So as it says on the slide there, some of the provisions will come into effect at the point of royal assent being given or soon thereafter. And one of those is the repeal of the trade union legislation, which I will talk about later on. And then we move into April next year, where we've got the changes to statutory sick pay and the protective award doubling. Then we fast forward to October next year, where we've got employment tribunal time limits being extended and protection from harassment from third parties being implemented. And then looking even further forward, we get into 2027, where some of the more controversial changes come into effect. So these are the ones that have been slightly more headline grabbing around day one unfair dismissal rights and 0-hour contracts and the changes to those. And I'll talk about the changes to 0 hours a bit later, but as it says there, 2027, we are quite a way off that, but it's obviously a concern for a number of you and for us, and working out how that will work in practice. If I now just hand back to Abisola just to discuss the kind of latest chapter and the key updates between April and October.
Thanks, Francesca. So as I mentioned earlier, one of the key things that we're going to look at today is what's changed from when we last spoke to you in April to now. And we've got three key things that we want to talk about. So the first update was on the 1st of July when the implementation timetable was published. So as you saw a couple of slides before, when Francesca was going through when the various provisions are due to come in, we've now got an idea as to when we can expect the various different changes. As Francesca said, some of the meatier ones are coming towards the end of that timetable, so 2027. But what that does mean is that we've got an idea as to how to plan for those various different changes. And as we say, we'll look at some of those which are coming in, some that we can expect to come in sooner, a little bit later. And then later in July, we had, again, what we're going to spend a bit of time talking about today, which is some more government amendments to the legislation. So the Employment Rights Bill, as Francesca said, has gone through a bit of a journey. And the latest amendments were tabled in July, which have changed some of the key provisions of the Employment Rights Bill. So we're going to have a little look in a moment at what those mean and what significance those changes hold. And then finally, in September, we had a cabinet and minister reshuffle. So the Secretary of State for Business and Trade was changed to Peter Kyle. And we also had a new change in Employment Rights Minister to Kate Dearden. Some of the concern around this reshuffle was whether that will have an impact on the implementation of the bill. As we've seen, we have got an implementation timetable now. But helpfully, Peter Kyle has confirmed that, or has committed to there being no slippage in the timetable. So hopefully the timetable that we've got at the moment should stay as it is, and we can plan towards that. So if we move on, what are the latest government amendments to the bill and what impacts do those have? We've picked out four of the key ones on the slides, which we'll go through in turn. I'll just briefly look at the extension of parental bereavement leave first, and that's perhaps the least complex of the most recent amendments that we've seen. So as it stands at the moment, an employee is entitled to either 1 or 2 weeks off on the death of a child under the age of 18 or the loss of a pregnancy from the 24th week of pregnancy onwards. And what we've seen is an extension to that under the amendments to the bill. So as of 2027, so this is one of the later changes that is due to come in, then an employee will be entitled to parental bereavement leave on the loss of a pregnancy at any stage. And what I would say is that that's consistent with a lot of the family-friendly rights and extension of those family-friendly rights that we're seeing under the Employment Rights Bill. And I'll come on to talk about some more of those slightly later on. Francesca, can you update us about the zero-hour arrangements and what's changed in relation to that?
Yes, thank you, Abisola. Yes, so we're having a look at 0-hour and low-hour contracts, and this is a question that we're getting a lot from clients of the impact of this is naturally large, and many of you will be concerned about how it's going to work in practice and what that means for flexible workforce. So at the outset, Labour promised to ban exploitative 0-hour contracts, but what has been proposed has been a shift away from an outright ban, but still a focus on protecting those individuals engaged on 0-hour or low-hour contracts. And the changes that they're proposing are on the slide there. So we've got right to guaranteed hours based on a reference period, right to reasonable notice of shifts, including changes and cancellations, and right to payment for late cancellation or curtailment of shifts. But I think while there has been this focus and we have slightly more clarity on what's being proposed, as I mentioned before, we need the regulations to come in to flesh out what the reference period will be around the guaranteed hours. So we're anticipating it will be likely around 12 weeks, what the procedural requirements are around the offer of a new contract, what the minimum notice periods will be, and what that level of compensation will look like for late cancellation and curtailment and when it must be paid. So, and along with what low hours actually means, because that in itself isn't clear. The government have expressed that they don't want this to be a token nod to protection. They want the change to be meaningful and impactful, but just quite how far that goes, we're currently not sure, because, as I said, we need those regulations in place. But one thing I do want to point out is that there is provision in there for employers and workers to agree to almost contract out of entitlements via a collective agreement. So whilst the changes are significant, there will be various measures in place to kind of figure out how it works out in practice, and also provide some carve outs, as is the case with much of employment law regulations. So the next focus has been also on the restrictions on the use of non-disclosure agreements. So this has been a subject of scrutiny for such a long time, and there has been a focus on whittling the ability to use these, and how that is those restrictions are put in place for quite some time. But what's been proposed under the Employment Rights Bill and what is coming in, albeit I must say that there isn't an implementation date yet proposed for this, but the provisions are that any confidentiality agreement which is in a non-disclosure agreement, if it contains a clause which prevents a worker from making an allegation or disclosure relating to discrimination or harassment, or the employer's response to that, the provision will be void, the clause will be void. And what an allegation or disclosure relating to discrimination or harassment will cover is really any breach of the Equality Act. So it will include, for example, an allegation around failure to make reasonable adjustments, and curtailing the disclosure of information around that will be void. So again, it is a significant shift, and what I would say at this point, and certainly what we're doing and we're advising clients at the moment in respect of this space, is to be looking at the drafting, to be looking at the clauses which are included in these types of settlement agreement, Cut 3 agreements, whether you have precedents of your own that you need to be reviewing and updating, because that it will stand in good stead. So although, as I'll come on to later, it's not a case of jumping in and trying to change everything immediately to get ahead, this is one of the things that can be thought about now, in terms of drafting around that. If I now just hand back to Abisola to have a look at another of the changes, the more recent changes around fire and rehire.
Thanks, Francesca. And similar to the provision on NDAs, really, fire and rehire practices have been the subject of scrutiny over a number of recent years. There have been a few high-profile fire and rehire exercises, and quite a lot of criticism about those exercises and how they've been handled. And as a result of that, perhaps there has been a commitment from the current government to outlaw fire and rehire practices. Just to briefly summarise what I mean by that, when we're talking about fire and rehire, we're talking about a situation where an employer might want to change terms and conditions of employment of one or more employees. Inevitably, you will seek agreement for those changes in the first instance. But if that agreement can't be secured, then the employer might dismiss the employees concerned and offer them re-engagement on new terms of employment. And the first iteration of the Employment Rights Bill had a proposal to make it automatically unfair to dismiss an employee for refusing to agree to any variation of contract. And what we've got as a result of the amendments in July is a more watered down version of that. And the provisions are now actually quite complex, but I'll summarise them in broad terms just to give you an idea as to what the new provisions, as they're due to come in, will mean. So now, rather than being automatically unfair to dismiss an employee for any variation of contract which isn't agreed, there's now the definition of restricted variation. So there's sort of two categories of potential changes to terms and conditions. If the potential change is a restricted variation, then dismissing an employee for failing to agree to that variation will be automatically unfair. If the variation isn't a restricted variation, then the dismissal won't be automatically unfair, and any unfair dismissal claim will be considered in line with normal principles. But there will be a number of factors that the employment tribunal has to consider in determining whether that dismissal is fair. So things like what the employee's been offered in exchange for that variation. So clearly the key question here is, what is a restricted variation? And in broad terms, I'd say that it's generally things that are intended to drive down the terms and conditions enjoyed by an employee. So it covers things like a reduction of pay and benefits, a reduction in hours and work, or shift patterns, or a reduction in the amount of time off that an employee can take. So those are the sorts of things that will be automatically unfair to dismiss an employee for refusing to agree to. What isn't a restricted variation, so what's notably missing from that list? So as it stands at the moment, under the new rules, it won't be automatically unfair to dismiss an employee for refusing to agree to a change in job description or location of work. And I should say that there is still an exception from the regime under the Employment Rights Bill in relation to a circumstance where the change is being proposed in order to eliminate, prevent, or significantly reduce or mitigate the effects of financial difficulties which are affecting the employer's ability to carry on as a going concern. And as such, the variation can't be reasonably avoided. And there's going to be an equivalent exception for the public sector, including public authorities. So again, there are circumstances in which this new regime isn't intended to apply, but those are fairly narrow. The other change that I should mention in relation to this provision is that a loophole was plugged by the government. So under the previous iteration of the bill, a dismissal wouldn't have come under this regime if the employee was going to be replaced by a non-employee, so an agency worker, for example, whereas that loophole has been plugged. So what does that mean for employers? So helpfully, as I say, we have got a watered down version of the regime, so not all proposed changes to terms and conditions would come within it. There is slightly more flexibility under the amended version of the bill to propose a change in terms and conditions if it is change of job description, change in working location. But I think we've got to acknowledge that it's still going to be much more difficult and costly for an employer to change terms and conditions where there isn't agreement. So clearly, to the extent that an employer is considering an exercise of that nature, it would be sensible to try and do that sooner rather than later. This element of the Employment Rights Bill is due to come into force in October next year, so around a year away. So a careful planning around exercises of that nature would be sensible. Francesca.
Thank you. So we've had a look at the changes. So now just going back to the screen that I had around the timetable. So the first two phases of the Act coming in will be the priority in terms of your focuses and changes coming in. So at royal assent or soon after, so on the day of the bill receiving royal assent, we have the repeal of the Conservative Trade we have the repeal of the Strikes Minimum Service Levels Act 2023, which was brought in by the last government to allow the government to set minimum service levels during the period of strike in key sectors such as health and fire and rescue. But it proved to be controversial, so there's been movement and will now be movement for this to be repealed. So that's imminently on the bill receiving royal assent, but within 2 months after royal assent, there'll be the repeal of the Trade Union Act 2016. So the potential impact, the provisions arising out of that and the impact of that most of that being repealed are, as it says on the slide there. So only a simple majority will be required for industrial action. The length of notice, which is required to give an employer of an industrial notice, is reduced from 14 days to 10 days, which again is significant in terms of preparations being able to be put in place in the event of strike action. And also we have extensions around the current protections of individuals planning to or engaging in strike action, in that there is protection against dismissal throughout the period of a strike. So a number of repeals and movements away will need to be at the forefront of minds pretty soon, either after receiving royal assent or very soon thereafter. In terms of April 26, I'll hand back to Abisola.
Yeah, so we've popped some changes on the slide that are due to come in the next 6 months or so. So hopefully that gives you a little bit of time for planning for these changes. So the first one is a change to the statutory sick pay regime. And this is potentially one of the more significant changes in terms of financial impact on employers, but it very much depends on the sector in which the employer operates and the provisions around payment of sick pay at the moment. So just to summarise, firstly, what the changes are going to be. So as it stands at the moment, as you'll know, statutory sick pay is paid from the 4th day of sickness absence, and there's a lower earnings limit requirement for those who are entitled to SSP. So that's currently around £125 per week, albeit that figure changes year on year. And what we're going to see as of April next year is that that's going to be widened in scope. So SSP will be payable from the 1st day of sickness absence, and it will also be paid to those who earn below the lower earnings limit. So in terms of the actual amount that employees will be entitled to, as it says on the slide, it will either be 80% of normal weekly earnings or the standard rate, which is currently around £119 per week. Again, changes year on year. So you can see that for some employers, this is going to have little, if any, impact. If you as an employer already provide for enhanced sick pay, which is paid to everyone irrespective of earnings level, and from the 1st day of sickness absence, then clearly this won't have an impact. If, on the other hand, you're in a sector where sick pay entitlement is based on SSP, and you've got a large number of low-paid workers, then it can potentially increase the pay bill quite significantly. So it's estimated that there'll be around 1.3 million workers who currently don't qualify for sick pay who will be entitled to sick pay from this point onwards. And it's also estimated that it will be around £400 million in terms of the financial impact. And you can also see that it might have an impact in terms of levels of sickness absence. So there's some research which should suggest that perhaps unsurprisingly, a greater level of sick pay can lead to greater levels of sickness absence, albeit the government disputes this. On the other hand, you might think that if an employee does now become entitled to sick pay from the start of their sickness absence, that might give them the opportunity to recuperate at an earlier stage, therefore meaning that they have a lower period of sickness absence overall. So we will have to wait and see what impact these changes have. The second change, again, potentially has a direct financial consequence for employers, and that's the doubling of the protective award, which can be awarded by employment tribunals. So the protective award is the amount that the employment tribunal can award against an employer in a circumstance where it's failed to comply with its collective consultation obligations in a redundancy scenario. Currently, that's capped at up to 90 days gross pay per affected employee, clearly quite a significant award, and it's due to become even more significant at up to 180 days gross pay per affected employee. So clearly that will make the penalty for failing to comply with collective consultation obligations much more costly. We might also see it being used as a negotiating tactic or something to put pressure on employers by employees and unions in a collective consultation scenario. It has been pointed out in the context of consultation around this change that quite often where an employer does fail to comply with its collective consultation obligations, that may be as a result of failing to understand the fairly complex rules around collective consultation rather than a willful intention to disregard the rules. So what the government has said in response to that is that it will publish guidance on how employers can do this, so that will hopefully be helpful as and when we receive that. And then a couple more changes for April. So the first one is an extension of entitlement to paternity leave and unpaid parental leave. So currently, an employee has to have 26 weeks service to benefit from paternity leave and a year's qualifying service to benefit from unpaid parental leave. Both of those will become day one rights. And as I mentioned earlier, that's very much consistent with a move towards increasing family-friendly rights. That will have less of a financial impact on employers because we're talking about leave rather than pay entitlement. But what it might mean is that there's an increased administrative impact of those changes. So having to update policies and procedures to reflect the changes, potentially having to make accommodation for employees taking leave when they wouldn't have otherwise, having to deal administratively with applications for leave. So that'll be something that needs to be planned for within HR teams in the coming months. And then finally, Francesca's already mentioned a number of changes to trade union related rights. And there are some further changes due to come in April in relation to the trade union recognition application process. So this is something that perhaps won't really have an impact for employers who are already unionised. But for those who aren't unionised, but you may have trade unions who are sort of waiting in the wings, as it were, for recognition, then it will make the application process much more straightforward for them, fewer hurdles to jump through. So to the extent that you are in that situation, it would probably be worth having early and constructive dialogues with those unions, considering voluntary recognition if that's appropriate, to give you slightly more control over that process. And then we'll also see the introduction of electronic balloting as well. So again, this will make engagement in industrial action balloting much more straightforward, perhaps, for employees. So again, early engagement by employers with employees over potential disputes would be sensible in the light of that. And then finally, just to pick out a few government consultations and proposals that are in the pipeline. I'll perhaps just pick on the first of those, which is in relation to employment status. You'll know that the vexed question of employment status is one that's been battered around for a number of years. And we're coming back to that question as to whether, rather than having statuses of both employee and worker, we should just have one single status of worker. As I say, it's a question that's been around for some time now, and we're due to see further consultation on it. Certainly wouldn't see any changes in this area for a number of years, I wouldn't think, because of its significance, but it's certainly something to be aware of.
So just having a look quickly at the potential impact and action points moving from this. So as it says on the slide there, we've got the Employment Rights Bill, Employment Rights Act as a whole is going to have a large impact, whether that's from a cost perspective, administrative, or just practically working differently. So in terms of rise in direct and indirect costs, we've got additional challenges for risk management and also implementation of working practices and changing those. But what I think is a key change is what both myself and Abisola have mentioned around favourable union recognition and the focus on that. So as Abisola referred to, those early engagements with unions, early stages will be key to be having those conversations. But even prior to that, trying to think ahead, trying to consider risk and strategy around that and moving forward constructively will be key. And hopefully, given the timescales that we have in terms of changes coming into effect, that can be an ongoing conversation within organisations. And then just lastly, around action points, I think the biggest thing that I want to say, and what I've said to many already, is don't panic. This isn't a case of having to rush in and having to change everything overnight and implement things. I know and we appreciate that things are naturally of concern and are going to have a large impact. But as I said, we do have that lead in time, and we do have that clarity that's required still coming out of the regulations. So as we've said on the slide there, just being up to date and alive to the Employment Rights Act and the regulations and the changes. There are consultations around the changes coming in, so staying in tune with what those what's coming out of those consultations, participating in it, so that the organisation's view that you're working in is put forward and considered, and starting preparatory steps, but not jumping in and trying to implement new policies, new procedures, when actually it could be a drain on time and resources if ultimately when the regulations come into effect, it changes the position again. So I think staying in tune and thinking about it, but certainly not immediately implementing something right now. So that brings it to the end of what myself and Abisola wanted to cover today. But now is the opportunity just to go through any questions that we've had. I think we've had a few coming in through the Q&A. So do let us know if there are any questions, and we'll try our best to answer those.
Yes, and if I just kick off with one from one of my slides. So something that I didn't have time to cover over the course of the webinar, but happy to answer now. And Sarah's asked, so I referred on one of my slides to a few government consultations which are due to come in, and one of them was in relation to AI in the workplace, and Sarah's asked what that's due to cover. And I think that's quite an interesting one, and I think we have to acknowledge that AI is having a significant impact, of course, in all areas of life, not least the workplace. So the consultation is, I would say, split into looking at two different things. So one of them is looking at what impact AI is likely to have on jobs, work, and the skills of the workforce. And then another element of it, which I think will potentially be of great interest to employees and potentially unions, is looking at what the impact of the sort of surveillance element of AI will have on the workplace. So how can unions and employees best be consulted and involved in the introduction of surveillance related technologies into the workplace? How can we sort of look at and potentially reduce the impact of kind of discriminatory algorithms in terms of things like recruitment? So broadly speaking, that's what the consultation is due to look at on that.
If I just take a question of would a change in government change this bill, I think it's what many of us are talking about, that actually a lot of time and energy has been spent putting this into place, but actually a change in government could certainly, we see the polarization in views, so there could be some rowing back on provisions, as we've seen with the changes with the Trade Union Act. There's a back and forth given the polarizing of views. So I think it's certainly something that a change in government could row back and change some of the provisions. Absolutely.
And then if I take a question around, so the extension, so someone's asked about the extension to the duty to prevent sexual harassment to cover all reasonable steps, and whether this is still being considered. So you're absolutely right, and as you appreciate, as you would have seen on the implementation timetable slide, there are a huge amount of changes under the bill, so we weren't able to cover all of those, but you're absolutely right. Just taking it a step back for a moment, as you'll remember, in October last year, we had the introduction of the proactive duty on employers to prevent sexual harassment from occurring in the workplace, to the extent that that's practical. As the question, as the person who was asked the question says, that's due to be extended to all to an employer having to take all reasonable steps to prevent sexual harassment from happening in the workplace. If I remember correctly, that's due to come into force in October next year. That will clearly have a significant impact on the extent of the duty that employers are under. Certainly in terms of our discussions with clients, a lot of employers have made very good steps in terms of implementing the various provisions that refer to in the EHRC code on this to comply with the existing duty to take reasonable steps. So implementation of workplace risk assessments and that sort of thing. But clearly employers will have to consider again what further steps they will be expected to take to comply with that strengthened duty.
And there's one just on a section I covered around the NDAs. So the change to NDA and discrimination, does this prevent the claim from being settled or just prevent the employee from making future claims or disclosures? So it won't prevent a claim from being settled, but the terms under which that settlement is achieved, it will be restricted. So any non-disclosure agreement, it won't be void if it's contained within an accepted agreement. So that is again something which is to be defined in regulations, and the government will consult about it, but it's likely to consider non-disclosure agreements at workers' requests, or whether workers should actually receive mandatory independent legal advice before signing a non-disclosure agreement. So and whether that non-disclosure agreement must be time limited. So it doesn't prevent settlement, but it does restrict what can be said by an employee or disclosed, and that information it does restrict that. So it's just the careful language around looking forward, what you're preventing the employee from doing, the employee or worker from doing after that claim is settled or the matter has been resolved.
And then looking at a question from Joshua, so that's around the day one unfair dismissal rights that are due to come in 2027. And the question is around, so the question is, what about probationary periods? Can these be extended to account for day one unfair dismissal rights? And I'll say that so whilst the changes to unfair dismissal rights are perhaps one of the biggest, if not the biggest proposed change under the bill that's been subject to discussion, it's one of those areas that Francesca mentioned that we're still waiting for regulation to define quite what that will look like. But what we are expecting is that there will be, in a sense, almost a statutory probationary period. So there'll be a period within which it's easier or more straightforward to dismiss an employee. We're expecting, so that period hasn't been set yet, but we're expecting it to be something like 9 months perhaps. So whilst an employer's probationary period won't be automatically changed to match that, clearly it's going to be sensible to make sure that any probationary period is completed within whatever that timescale is, because that's going to be the period within which you're afforded a slightly more streamlined process to dismiss an employee for poor performance, for example. So what we're expecting employers to do is to keep an eye on what that statutory period is going to be, and make sure that probationary periods are updated in line with that. I suppose I'd say from a practical perspective, that the length of the probationary period is, of course, only half of the story. What we do see sometimes is that perhaps there can be a reluctance to manage performance during the probationary period. So as well as obviously making sure that the actual probationary period is in line with whatever the updated law says, there'll also need to be, I think, a kind of real effort by employers to make sure that managers are properly managing employees during that probationary period to make the most of it.
Are there any other questions, Abisola, that you've seen? And I think there was one around likely changes in the Trade Union Act 2016, which is the section that I covered, which is most of that act will be repealed 2 months after the royal assent. So imposing so it includes a number of the repeals, meaning that, as I said on the slide, if only a simple majority of members will be required, and that reduction of length of notice from 14 to 10 days. So that there are changes and repeals of that act, which are quite significant, and most of that act is to be repealed.
And perhaps if I just pick up one final question, so that's around the changes to fire and rehire. So Joe's asked a question around how that sort of interacts with flexible working. So if someone's got a flexible working agreement and the employer asks them to change their days of work, would the employee have to agree to the change, or would they be protected? And I think we've still got to look at flexible working and the fire and rehire provisions as separate things. So subject to what's actually been agreed. Generally speaking, where someone has benefited from a change to their working pattern through a flexible working request, that becomes a permanent change to their contract. The employer can't unilaterally vary that change, unless, of course, it's been subject to a trial period or something like that. And there's a sort of set provision which allows the employer to say, this isn't quite working, we're going to have to go back to your previous work pattern. Once you're outside any trial period and that change is permanent, then that employee's terms and conditions will fall in line with how the employer has to treat other employees' terms and conditions. So if it's proposing to make a restricted variation, such as a change to hours of work or shift pattern, then subject to getting the final detail as to what that looks like, then that likely will be a restricted variation, which will be subject to the new rules. So I think that's all of the questions that we're able to cover during the scope of this session. Just to say again, thank you very much for attending. We hope that you found the session useful, and we hope you enjoy the rest of your morning, and thanks again for attending.
Thank you very much.